these lawyers. And I will also refer them carefully, Regulation 63, which talks about the duties of the judge advocate. Sub-Regulation 1 says that the prosecutor and the accused respectively are at all times, after the judge advocate is named to act at the trial, entitled to his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court-martial as a field court-martial, general court-martial, or court-martial appeal court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintend over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Aaron Chisa as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D. Sometimes I never to read because when I refer that to read, they say I should read. So I will read. It says every person who is, right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Aaron Chisa, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because the person who was convicted before this court is not there, and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Chisa has a specific role, to me that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter is ably submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Kwago, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in reserve, were present, and all the members before you have been following this case, have been in court. So the fact that you are saying one is not there, whoever is there has been here or from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notice. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Bang, I will not go into it because I have already given my position. But Senior Council Karua said that me, as a brigadier to Kachungu, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my response.
Yeah, Mr. Chairman,